Welcome to the Indian Journal of Law and Public Policy podcast.
Hello everyone, welcome to the yet another episode of the IJLPP podcast. I am Aakash, Chandran, the consulting editor with the journal, and will be the host for today's session. Taking forward the stream of discussions we have had till now, today we'll be talking about the response of the Indian state against the COVID-19 outbreak. I have with me today the two fellow consulting editors of the journal, Pranav, Tanwar, and Saurabh Pandey. Pranav, if I may start with you, how do you see the Christmas state of affairs which you are witnessing in regards to the interstate migrant workers? Do you think we can reconceptualize this problem within the realm of international law?
Thank you, Akash. The question that you have asked, it's quite wide in scope. I feel, as to the number of events that have happened around the issue of migrants and corona as such as well in the last 1 month of lockdown. But in my answer, I will try to cover as much as I can within the time limit that we have for the podcast. First, I will appreciate the recent initiative by the government to run the train services for stranded migrants and other initiatives in the form of whether it's food distribution or Chandran Yojana, etc. But then, though appreciable, the news that has come around on migrants conditions has been really disappointing. We have seen migrants dying while cycling or walking their children back to their homes. Reports have come of poor food facilities or living condition in shelter homes as well. We witnessed also that how thousands of migrant workers came out on the street of Mumbai and Gujarat protesting and demanding safe passage to their home. I will go to the root of the issue as to why it arose, and then we will move on the how we can reconceptualize the entire concept of this problem. So if we see the reason as to why they are migrating, first is basically want of better livelihood, which we all appreciate, and that it's not only simply about migrants as well as it's about middle class as well, that when lockdown has got extended they are looking for savings and want of a better livelihood. And second is that amid this lockdown the economic activities are down and migrants are basically daily wages, so they earn on the basis of the work which is given on daily basis, and in amidst this economic activities being down, I don't see them earning on daily basis, and they don't have savings as such because they don't earn to that capacity. And third, it is about the safety from exploitation, proper food, and to be with the families which are there, which are living back at their home in other states. Now, as the reason as to why they have started to move in such a way, I feel the lack of time given to them to move or to go back to their homes was really less. The lockdown was announced in such a suspense and so suddenly back in March that it was bound to create panic. Now I understand this may have been done to prevent stocking of goods, etc. But then it must have been coupled with enough facilities to tackle problems which may arise out of such announcement. But thankfully, late than never, obviously those facilities are now made available. Now, I want to add over here the legal aspect now before we conceptualize this concept in light of international law, which is that as far I know, as in my readings go, there are few acts which relates to migrants. First is obviously this Interstate Migrant Workmen Act of 1979, which in order to address the unjust working condition of migrant workers, their right to return to home periodically without losing wages, and the right to medical care and housing has been guaranteed. But this law has been subdued by another most sovereign law of India, that is law of ignoring. So the law remains ignored and non-efficient. And Akash, I feel now, as you also asked about reconceptualizing it in the light of international law, I think it is necessary to note that the UN Human Rights Chief has expressed concerns regarding migrants in India. The one law which can guide our government as to what all laws shall apply for migrants, especially as they're affected by disaster, is the guiding principle of internal displacement. These principles list down various rights of displaced people, which of course includes migrants affected by disaster. So when we try to define them, they gets included internally displaced people because they are migrants who are getting affected by disaster. And no doubt the central government has itself called the present situation disaster under the National Disaster Management Act. Now, though the union executive has not accepted these principles internally, so at domestic level, these guiding principles have not been accepted by the executive. And when they have went to international forums, they have refused to accept them on the grounds that these principles were given by civil society and not discussed by states as such. But we have few judgments from Delhi High Court, in fact two judgments, which have considered GPID as an important guide on IDPs of India. So anyway, these principles are derived from other international human rights and humanitarian law documents which are binding on domestic government. So they have the backing of other internationally binding obligations on India. If I list out the principles which could have been of help to us, includes right to life, which is under principle 8 of the GPID, and an adequate standard of living, which is under principle 18 of guiding principles of internal displacement. So they will help in awareness, and so we can reconceptualize that if these principles were there, there could have been awareness, there could have been better national strategy and plan of action without putting an extra burden on domestic law. So just to conclude, I would say that we really need to introspect what we are actually missing in our legal system. Yes, our bureaucracy, as efficient it has made superb executive action on migrant problems, but a legal setup will go a long way in such unprecedented situation, especially when such a huge population is migrant in India.
Right, Pranav. So, for the benefit of listeners, I would just want to clarify that GPID, Guiding Principles on Internal Displacement, is emerged has emerged out of, like you said, the existing principles of international law. So therefore, in any case, migrants are, as citizens of the country, are under the protection of the human rights law. But what guiding principles do is that they enhance or they bring out the vulnerabilities of the migrant or as internally displaced person, so that a more proactive and a better framework of rights can guarantee their, violation of the civil liberties. Having said that, Saurabh, if I can come to you now, uh, how do you mark the government's response and its communication with regards to the pandemic? I'm asking this because we are bombarded with multiple half-baked notifications, which often leads to uncertainty and does not give us a clear picture as to what is happening or what should be done in the coming days. So yeah.
So, thank you, Akash. I'll take that from Pranav, where he very rightly mentioned that all this happening was done in very suspenseful way. All this announcement regarding the lockdown and all other things were done in a very suspenseful way. So nobody could anticipate, especially the migrant workers, where they don't have knowledge about what is going in the country because they are only worried about their meal of two time and about earning of a day, where they were not aware about anything happening around. Then they were bombarded with these kind of things where lockdown was happened, trains were stopped, nothing was moving, and everything was happening so strictly, so they were stuck down. Also, there was so much of ruckus initially. Why? Because we really need to understand that in last 70 years we haven't seen such kind of situation. So none of the bureaucrat was ready for such kind of thing where we are seeing the lockdown. Especially even when you see the Indian Railways, it has not stopped even during the wars, but this time it was stopped. So this was like confusion was prevailing all over the country, like what will happen, what will not happen. And also uh, uh, on the day one, our prime minister announced a lockdown for only 22nd of March. That was Janta curfew, and after that people were anticipating that this will happen. And at that moment, all the on 22nd March only, things were locked, like all the states were locked, all the districts were locked, which made really difficult for migrants. At the same time, government also came up with the policy on 26th or 27th of March. Our finance minister came and she announced various policy measures and also 1.76 lakh uh, fund directly indirectly for the people of this country, and also various other measures, which is really commendable, and the job was really well done at that moment when she came up with this policy. But the flaw was it was not implemented as fast as it should have been. It took almost 8 to 10 days to implement that policy, and which created various issues, and it continued in a chain which resulted in the problems which we saw in second lockdown, people dying on the streets, people cycling from one state to other just to go to their place. Why? Because Akash, we really need to realize that people like who are migrants, they really don't care about. There was this situation where they really knew that they are going to die, and then they really felt that it's better to go die in their hometown than to die in a place which is not their hometown and which is just their uh, workplace. Regarding policy, initially, Akash, policies were framed really well, but there were some hiccups. But overall, executive managed really well in implementing the policy. But more steps could have been taken, especially regarding migrants. Like in Delhi and all major states, there was issue regarding food, but it was managed. Also, I really want to appreciate all those NGOs and other good people, especially police forces, where they provided food packets to all the migrant workers. And also, this has made us realize the situation that still like millions of people do not get food, and we really never gave heed to this thing that people are sleeping hungry. India's rank in global hunger index is almost 100 to 103rd since last 2 3 years. So this has attracted our attention towards this thing also, that people do sleep without food, and something like some major policies should also come into this field. And regarding other policies, especially in lockdown 3, when we see this lockdown 3, many things have been relaxed, and dividing red zone, orange zone and green zone will definitely help the economy also. And bureaucracy in last 60 days, executives have realized that what are the various issues and how they have to tackle step by step, and they have tried to do. When you see bringing back migrant workers, we now have Shamik trains, bringing back the students from Kota, especially governments of Uttar Pradesh, governments of various other states, like even Chhattisgarh government was ready. Especially government of Uttar Pradesh has done commendable job bringing for this, bringing students from Kota. They have sent buses and they have ensured that medical thing is done. So this is commendable. Executive has done a really good job, and things could have been done in a much better way. Things could have been more clear. We realize transparency is very important. When you see these kinds of situation, we realize that how media can work and how media should work, which media hasn't done very good job, which we did expect from them only. Executive also has limitation regarding the legislative actions and also the political compulsion. But overall, I would say that apart from some few hiccups, executive has performed really well.
Right, Saurabh. So since we're already talking about the notifications, would you like to comment on the legality of the same? I mean, we aren't sure if the legal basis of this notification would withstand the constitutional scrutiny. We are, as perhaps as Gautam Bhatia puts it, under the rule by the executive. What do you think?
Yes, Akash, this is one of the major issue which questions which comes to everyone. And also, this is the time when people are saying we are living in pseudo emergency, or we are living in the lawless society. Why? Because each and every law which is being enacted, and each and every notification which is coming out is a form is from executive, which derives its authority from legislation, but it's not directly deriving it. Now I will give you a few examples. So we have right now Disaster Management Act and Indian Epidemic Act. Both these acts does not mention anything directly about all the notification, like paying wages, paying not laying off, retrenchment, anything regarding this. But yes, orders have been passed like for the payment of wages and all other things. When you see section 25C and 25D of Indian Industrial Dispute Act, that simply mentions about layoff and compensation to be provided. Now that act has been that section has been enforced, but that doesn't help us directly and the migrant worker also. Now what we need to understand that implementing all these sections will not help until unless government provides fund to the private players, because private players do not have funds to pay for more than a month or 2 months. That's practically impossible, and that will ultimately affect our economy. Why? Before this COVID, we really we felt this, that economy was slowing down, economy was working not working in a proper position, it was really growing in a very slow pace. So after enacting these notifications, these will ultimately affect economy because the private payers do not have money to give the salaries, and also that's not practical to like we see the example of Canada, New Zealand, Netherlands, where the government has come into action and they have provided they have came up with the funds to provide money to the workers and to ensure that factories and big private players do not suffer. And also, when you see Disaster Management Act, we have Section 10, which mentions about National Executive Committee. We have Section 22, which mentions about State Executive Committee. Now, these two committees are formulating the policies, formulating the executive actions, and they are passing out the order regarding these migrant issues, migrant wages, and all other issues. Now, these are just regulatory norms. You cannot enforce. There is this term used in Section 51 of this particular act, without any reasonable cause. So when you read this section, you realize that these cannot be enforced. Person cannot be enforced to do this. Why? Because Section 51 clearly lays about the penalty for non-compliance. But if you have reasonable cause, also, Akash, regarding this industrial dispute code which is coming up, and parliamentary committee has mentioned in that uh, such kind of situation like epidemic of like corona and all other things will come into an unforeseen events where the industries cannot like industry can tell the workers that they are not in a position to pay the wages, and this will not attract any penalty or any other kind of punishment or any other kind of actions from the government and also executive. So when you sum up all these sections, when you sum up all the legal orders, we really we realize this, that nothing harsh, no harsh steps can be taken against the private player, and they are also in a position to directly tell the states also, and also the migrant workers, that they are not going to pay the wages because they don't have money. Also, we have seen this particular ordinance by Kerala government, where they state the salary of state employees for particular days, and now they have taken ordinance route because Kerala High Court stayed that particular order. So ultimately, Akash, what I feel that legally the orders are weak, and nothing harsh can be taken against these private players. So something else has to be supplemented with these particular notification and all other things.
Right, Saurabh. So, Pranav, my last question would be to you. Uh, like Saurabh said, the legal clarity is nowhere to be seen. However, we have another initiative by the government, and that is in the form of the Aarogya Setu application, mobile application. And it has, in some corners, triggered the same fear and anxiety that people had in regards to Aadhaar. The optional policy has changed into now compulsory directive and has hit at the center of the privacy debate again. So how do you see this uh, coming to picture now?
Okay, Akash. As to Aarogya Setu app, to be honest, I really can't make a clear choice on what shall be my preference of idea talking about this app. People are really divided over the use of app. There was this representation being made by over um, more than 100 of organizations to the Prime Minister office as to how this app is actually violating privacy norms. But then there has been arguments by the state as well. Today there was a press conference by the Union Minister Ravi Shankar Prasad where he defended the app, and I feel the idea this time is much more grave considering its relevance in the time of pandemic. Um, if I divide the arguments on both the sides, on the pro privacy side, I see three main issues. First is the issue of data which is being taken. Is that proportionate to what is required? Personally, when I use Aarogya Setu app, the data they needed were few mandatory permissions to effectively use the app, one of which is Bluetooth use in order to see that anyone who I come in touch with, if that person has corona, I get the alert on my app. Further, this Bluetooth allows location and keeps feeding me data on how many positive cases or probable cases are there around me within 500 meter, 1 kilometer, and 2 kilometers. Second is the issue of lack of legislation to back it up, in which Saurabh also pointed out, and you also indirectly asked in the question as to legal clarity on the setup of this app. And this is where the main concern for the app arises, that it does not have a legislation to back it up. It does not have norms or standards as to on which basis the data is being collected. And this goes against the privacy judgment of Puttaswamy. And otherwise also, basic tenets of privacy requires a legal backing for any such activity which involves use of personal data. Third is the involuntary use for its for specific sectors. And when I talk about there is no legal backing, this is one of the areas where confusion comes out, because some private entities has made it mandatory for its users. So for example, some delivery services like I won't take particular names. So some particular private entities has made it mandatory for their employees to download this app in order to make any delivery. Now it is according to any government directive, it has not been made mandatory for private entities, but private companies are themselves making it mandatory for their employees. So this is the problem which arises out of if there is no particular legislation to back it up. Now, when we talk of the government side, they have few things in their favor. The data which is taken for registration is posted on secured servers, and all these servers, there are two servers in India right now. One is in Maharashtra, another is in Bangalore. They are government owned, though the app has been made with the collaboration of private sector. The collaboration was limited to developing the app. Now when I use this particular app, whenever I give my data, that goes to a secured server, which in return provides a DID, which is called device ID number. This number is unique and randomly generated, and this number is used for identification for all future transactions. So whenever after my registration on the basis of my personal data, all the future transactions after that takes place between me and the server on the basis of this number. So there's no personal data involved after I have registered myself. And when a user comes in contact with another, it's the DID numbers which are interacting with each other as to send personal data, as to send notifications if there is any threat to me when I'm coming in touch with any person who probably or has coronavirus. And only when one gets tested positive for corona, or there is a positive alert as to other person has coronavirus, this DID number, this number gets reconnected to my personal information. And further, the government has, after criticism, made some changes in its app as to the limit on the limit on the time period for which the data is stored. So data is wiped out after 30 days for normal person. If it is stored in a central database, it gets removed after 45 days. And for those people who have corona, the data gets wiped after 60 days. Also, the data of users is not shared with third party apps according to government notification. And Akash, we have to note that this has all been done by the government in improvisation after criticism of its security over this app. So we will have to appreciate this brilliant move by government to ensure privacy interest of the users after the criticisms were made. Personally, I feel these are extraordinary times. I am remembered of Fuller's Special Explorer case, where he argues through one of the judges, where one of the judges said that the cave needs laws of the cave. We cannot apply law of normal society when we are talking about a situation which happened in a cave. So this situation may also require some curtailing of freedom, including right of privacy, if there are some emergency laws in place, which includes NDMA executive orders. And firstly, as such, I don't see any major intrusion in privacy by app. And secondly, for ensuring health and safety, the app is impeccable in the innovation. Even the World Bank has appreciated the app. The innovation, the idea which has went into the app in order to make everyone feel safe. We have talked about data has to be disseminated to people in order for them to feel safe. And this app is actually doing that by providing me information as to the number of cases on live basis. It takes 15 minutes for the app to get live data. It gives me information as to number of people around me who are suffering from this virus, and makes me feel secure as to, at least from data perspective. And obviously, I feel if the government passes a solid law to back the app with the sunset clause meaning that the erasal of data after the pandemic is over, it will be a win all for everyone. I feel sometimes you have to look beyond legal technicalities and appreciate what time needs for us. And change is sometimes good, change is sometimes bad, but most of the time it is both. And that is where the circumstances of today need us to make a choice, which requires us to, which does good for all with some sacrifices. So I feel app has certain technical faults as that too are limited to legal technicalities. On the privacy front, I see it as a secured app, but yes, when we talk about what Saurabh pointed out, that there has to be some clearly legal implications of what we are doing. You asked in the question itself that is there no confusion as to the law? Yes, there is confusion as to the law, but as such in the app, I don't see any fault. Yeah.
All right, Pranav, although I personally may disagree with the cave analogy you draw, but I'll take that with you personally. Thank you, Pranav and Saurabh, for joining me today, and we'll be back
Thank
next
you.
week for law and policy updates.
Thank you for listening to the podcast. Do not forget to check our website for more updates and legal articles. You can follow us on Twitter, Facebook, and LinkedIn. See you next time.